It's 2 o'clock, and the Code Enforcement Board meeting is called to order. Bobby, please call the roll.
Yes, sir. Ms. Wade is absent and excused. Mr. Perfidio?
Here.
Mr. Weeks is not present today. Mrs. Telliar?
Here.
Mrs. Archer?
Here.
Mr. Rollinson? Sorry.
Here.
Strange people's names. Dr. Matea? Absent. And Mr. Ogle? He's
Here.
present. Thank you.
I want to say the invocation, in the name of the Father, and the Son, and the Holy Spirit. We seek blessings on the task before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We pray that our work this afternoon will find favor in your sight. In the name of the Father, and the Son, and the Holy Spirit. Amen. And please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated.
These chairs are heavy.
Please silence all your cell phones. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs, providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the Circuit Court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal.
With that, I will discuss the hearing procedures for today. The matters before the City of Tarpon Springs Code Enforcement Board are quasi-judicial in nature. In a quasi-judicial proceeding, the board's function is to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the City of Tarpon Springs Code of Ordinances. This is a legal decision regarding the alleged violation before the board. The board may only consider evidence that the law considers competent, substantial, and relevant to the issues arising from the alleged violation. If the evidence demonstrates that the respondent has violated the Code of Ordinances, then the board is required by law to find that a violation exists. If the evidence demonstrates that the respondent has not violated the code, then the board is required to find that no violation exists. Any and all persons providing testimony at this hearing are required to do so under oath. All persons testifying at this hearing must give their name, address, and must indicate whether or not they have been sworn for the record prior to proceeding with their testimony. All testimony and questioning at this hearing must address matters that are relevant and material to the alleged violations of the city's Code of Ordinances. Any board members who have disclosures, such as ex parte communications or conflict of interest, please make your disclosures at the beginning of the hearing. The following is the established procedure which will be followed at this quasi-judicial hearing. First, if it is established that proper notice of a hearing has been provided to the respondent, a hearing may proceed in the absence of the respondent. The chair may request the respondent or the representative or attorney and their witnesses may request identification of the respondent, their representative or attorney, and their witnesses prior to the case hearing. All witnesses shall be sworn in by the secretary. The city will present its case, and the respondent shall present their case. Both parties will have an opportunity to cross-examine all witnesses. The board or its attorney may question any witness it feels necessary. The right of parties to present rebuttal evidence is discretionary with the board. The board may, in its discretion, adjourn a hearing for a period not to exceed 31 days at any time during the hearing and request further information from either party, being the city or the respondent. If a hearing is adjourned at the time the hearing is reconvened, only those board members that have been present from the beginning of the hearing may participate in the deliberations and decision-making process. Upon the completion of all the evidence, the chair shall close the public hearing, and the board will consider the evidence which is presented during the hearing in reaching their decision. At this time, anyone who will be presenting testimony, please stand and face the secretary to receive the oath.
right here.
Right over here.
Do you swear the testimony you're about to give is the whole truth and nothing but the truth?
I do.
Thank you. See it.
Okay, the first case is 23-8000062, Craig Eric Johnson, TRE, Christian Marie Jarvis Johnson, TRE, Christian Marie Jarvis Johnson, and Craig Eric Johnson, and it's at 1410 Poinsettia Avenue, Tarpon Springs, Florida 34689. And is there anyone here? Okay, would you please go to the podium, state your name and your relationship with regards to the property and the case.
Okay, hi, good afternoon. Kristen Johnson, and my husband Craig Johnson is here, but I was going to do the speaking if that is
Could you
okay.
speak into the mic, please?
Yes, Kristen Johnson.
Right.
My husband Craig Johnson is here. I'm going to speak. If you need his testimony, he is also available. Before I start, we might have a conflict of interest that I wanted to bring up to your attention. We noticed that Mr. Rollinson works at the same company as my husband. I don't know if that is a problem.
What do you do there? No? Okay.
They don't know each other, but I don't know if it matters. I just wanted
head
to
up the
disclose it.
corporate security team for PSCU.
1, 2, 3, 4 of 7. We still have 4 members who are able to vote on it. So you'll have to file a voting conflict of interest form.
Okay. I'm just,
You could still sit here, but you just can't cast your vote.
okay.
Okay, and would the city present its evidence?
This is not a homesteaded property. On March 16th, 2023, I inspected the property located at 1410 Poinsettia Avenue due to a citizen complaint. The residence is being utilized as a short-term vacation rental or tourist home and is advertised online as such. The property falls into the single-family residential district R100, which does not allow for a tourist home, nor does it allow for a conditional use permit to apply for. Due to this, the tourist home would need to cease. The property was posted with a notice of violation with a compliance date of March 30th, 2023, a copy mailed to the property owner via certified mail, and posted at Tarpon Springs City Hall. On March 22nd, 2023, the property owner, Ms. Jarvis Johnson, sent an email to the division requesting an extension until April 30th, 2023, due to a vacation planned from April 4th to 15th and having to work from March 27th to 31. The email also continued to state that she requests the citation be removed as there is a misunderstanding of the code and our rights as homeowners. She stated that our home is conforming use with the current code, that the state of Florida prohibits any city ordinance that infringes on our right. On March 22nd, 2023, I spoke with the property owner, Ms. Jarvis Johnson, via telephone. She advised that she was an attorney and was well aware of her rights, which are being violated, along with the city's violating the state statute. She was advised of the ordinance codes that were in violation and the reason for the violation due to the property being in a residential zone that does not allow for tourist homes. The property owner was very argumentative and stated that she wanted an extension as she will be traveling next month for a family vacation. She was advised that an extension could not be granted on a violation that has no remedy except cease doing it, which can be done at any time. She was also advised if compliance is not met that the case would be referred to the Code Enforcement Board for consideration of daily fines, and if found in violation, she was provided the next date for the hearing, which would be April 13th. The property owner then stated she wanted to go to the hearing, however needed an extension on the hearing date as she would be traveling out of town. She was advised that reasonable time had been given for compliance and would also be given for the hearing per Chapter 162, and that the hearing dates cannot be rescheduled due to a family vacation. Ms. Jarvis Johnson continued to dispute the violations and the dates and stated she wanted to speak with the city attorney and was provided his information. A re-inspection was completed on March 30th, 2023, and found that no efforts had been taken to bring the property into compliance. Due to noncompliance, the property was referred to the Code Enforcement Board. Several further inspections were completed on April 13th, 21st, and 26th, and found that no efforts had been taken to bring the property into compliance. It should be also noted that on April 21st, 2023, I spoke with a neighbor who contacted the police department due to an ongoing noise issue at the residence. She stated that the property had been used for a short-term vacation rental, and she has had to contact the police department several times regarding different renters. Compliance can only be achieved by ceasing the use of the property as a short-term vacation rental or tourist home and removing the advertisements. A hearing notice was posted on the property on April 26, 2023, a copy mailed to the property owner via certified mail and posted at Tarpon Springs City Hall. The division recommends giving the respondent until May 25, 2023 to achieve compliance. If compliance is not achieved, the suggested daily fine amount adopted by the board would impose a fine of $75 per day, beginning on May 26, 2023, until the property is brought into compliance. Exhibit 2 is going to be the R100 Single Family District designation. It also has the online advertisement for the home. It also has a photograph of the dates that are available to check out. Exhibit 3 is going to be the notice of violation, the certified mail receipt, the signed signature card, and the affidavit of posting for that, as well as the notice of hearing, the certified mail receipt, and the affidavit of posting. That would be for the first hearing that we came to, and the board agreed to give an extension of 30 days. The next notice of hearing is going to be for this present hearing, along with the certified mail receipt and the affidavit of posting. Exhibit 4 is going to be the property appraiser and the tax collector. Exhibit 5 is going to be a multitude of emails sent back and forth between the respondent, myself, and Mr. Salzman, along with attachments from the respondent. I believe that is it at this time. Oh, I apologize. There's one more. Exhibit 6 is going to be the definitions of a tourist home, a single-family dwelling, as well as all of the requirements, conditional use, and allowable uses for the R100 zoning.
I'm sorry to interrupt. My packet is missing a page of our submission. It looks like a page was skipped. Pages 5 and 6 of my letter, and then the first page of the exhibit that was attached to the letter. Like, it stops at page 4. I don't know if it's just my copy.
I printed out what I had, and that's all I have.
I have in mine has pages 5 and 6 of your correspondence.
Oh, okay, so it might just be this book that I have.
Does yours have page 5 and 6 of your correspondence?
I think this is 5 here, isn't it? Unless they didn't mark that one.
It may have been an error in the printing.
Might be there, but not the numbers, because there's more. Oh, I think this is 5, and not 6. Okay, no. I think they're there, just the numbers aren't on it.
Okay.
5.
I have it on my computer, so I can see it as long as it's in the packets.
Does it say number 5 and 6 at the bottom?
So it does. I can see it correctly in my binder, but that one is different. Can I see your binder?
See, these pages aren't on it.
think it's the page.
Last few pages, correct?
I only got two.
This must be 5.
I'm thinking too, because it looks like it reads.
It reads right into it, yeah.
So they are missing, they have page 4. What they do not have are pages 5 and 6.
This is page 2 on
I
this
think
one.
the first page of Attorney General Bondi's letter that I had included as attachment. Page 2 of that. I don't know if it's the same in yours.
It does look like there might have been a printer error
Okay.
in this. Mine did come out correctly. So what we can do is read it into the record. If you want to, if she wants to read the last 2 pages into the record for the board, that is an option.
Can we make sure just that the one that goes into the record is the one that has all the pages, your copy?
Yes.
She has,
The secretary don't
the,
have them.
So we
I'll
will
get
make
them from
sure that the record is complete with that correspondence.
Okay, thank you.
do you want us to go make copies real quick?
I think she's asking just that it be part of the record in case
Okay.
there's an appeal or something
Right.
along those lines, right?
Fine.
Yes,
We
yeah.
can agree to that.
But thank you. I appreciate that.
Okay. Do you have any issues with the city's evidence? And you have a copy of it there, obviously.
No,
Okay.
the physical, the paper, I'm fine because I have my own. I wrote it.
Okay.
Yes, please.
Does-
And we would like to move that packet into evidence, please.
Yeah, okay.
Yes, sir.
Bob, you accept
And I'll
that
get
as
the rest
evidence,
of them,
okay?
yes.
Okay.
Okay.
And Ms. Stoner, your credentials are on file with the city, correct?
Yes, ma'am.
All right, thank you.
So, does the board have any questions for city staff at this time?
Supposed to speak.
Okay, and do you have any questions of the city staff?
No, I mean, if there have been reported issues, we would like to know what they are, but is that something that's available to us?
Regarding the police reports,
You said there was a recent complaint?
yes, that was through the police department. You
Yeah.
would contact records at the police department, and they can get you that information.
Okay, homeowners aren't notified of that?
I don't believe so.
Okay. No other questions of the,
Okay. Does city
Inspector?
staff have any questions of the owner?
She's supposed to
She
give her.
has, she has the
statement.
opportunity now to present her case.
Okay, all right.
Just the
Now,
attorney right there.
you can present your case.
okay, thank you, Mr. Chairman. I'm Kristen Johnson. This is my husband Craig. First, I would like to express my profound gratitude for the extension that you gave us. I really appreciate that. We were out of town with our children. I did submit a letter in response to the notice of violation that we received, and I'm not sure if everyone had an opportunity to read it, but if you haven't had an opportunity, it is in the packet. It's the one that was missing the 2 pages, but I think most of you can see it. But what I would like to do is, obviously, I'm going to give my testimony. I took the oath, so anything I'm saying is affirming the facts that I'm saying. If you need to ask questions of Craig, you're obviously free to do that as well. But I wanted to give our position for the record on this notice of violation and our response to that. Just as a slight background on the property, we are private homeowners. We don't live in the property. We bought it as a second home. We spent about a year and a half fixing it up, and I included pictures. Did that exhibit get included in this printout?
No.
I did not have any photographs.
Is there any way for me to be able to transmit information to the board? Because on the notice of violation, there wasn't an address for me to send information to, so I sent it to the city attorney because that was the address I had.
All information and evidence needs to be presented within the context of this quasi-judicial hearing.
Okay. Am I allowed to show it on my computer?
You have to submit it to the city so that the secretary can make it a part of the record. And we'll have to document what photos you're sending to make sure that they're accurately incorporated into the record.
Okay. I'm not sure how to do that. They're the ones that I sent to you, Mr. Salzman?
I have no objection of you showing them on the computer, and then just, we'll forward them.
Okay. All right. And it's a set PDF document, so it's pretty easy. Let me pull that up really quickly. So I know it might not entirely matter on the decision about whether there's a code violation, but I do think it's important for context for you to know who we are and what we've done with this particular house, so you understand how we have reached the position we've reached on the interpretation of the zoning codes that are being enforced in this notice of violation. And so just with your permission, very briefly, I just want to show you this house. We bought it, it's 1410 Poinsettia. It was a single-family home. When we bought it, the owners have been there for, sorry, Mr. Chairman.
I'm just kind of curious what the bearing is on the case.
Well, I think
Just-
our understanding of the code and how we read it when we bought the home, I think is important, because there's, the code is supposed to be interpreted in a way and apply to individuals of common understanding and how we would understand the code. I can skip the photos if you don't want to see what we've done to the home.
Defer to the board. if
I can
you'd
just-
like to-
I can just submit
I don't
them.
see the bearing.
Well, it's a home, so.
I'm not sure if it's pertinent.
Well, my understanding was part of the reason for why the city is doing this is because they're concerned about the health, safety, and welfare of the neighborhood and of the city. And so one of the things that we did with the home, I'll skip the photos, but I mean, the home was very much in disrepair. The backyard was overgrown. I guess there were actually unlawful plants there. If you look on Google Maps, it looked like a jungle. We spent 1.5 years cleaning it because we actually love Tarpon Springs a lot. We've spent a lot of time here. We live in Safety Harbor, so we come back and forth pretty frequently. We bring our kids here all the time. And so we wanted to do something to beautify the city. And when we bought the house, we reviewed the code very carefully to try to make sure we were doing everything in full compliance. We've gotten all the permits as required. We've been very open with the city about our plans. And so it did come as a shock to us when we got the notice of violation. And what I thought was really interesting about the notice is that it cites the zone, the R100 residential zone, and then it cites the definition for a tourist home found in the definition section of the code. And then it summarizes at the bottom of the notice of violation that I don't want to misstate it. It summarizes on the notice of violation that the residence is being utilized as a tourist home, and then it puts in parentheses short-term vacation rental, which is not allowable in the current zoning district. And so it was surprising to us because it took the current zone, R100, and it said because this definition exists elsewhere in the code, the way that you're using the zone, which is defined as R100 allowing a single-family detached dwelling, which is what we bought and it's what we're using, it says that we're basically out of compliance with the zone because this definition of tourist home exists within the code. And I have a couple points I'd like to make on that. First, there's nothing in the R100 zone itself, when you look at the statute, that would naturally or in any way on its face prohibit leasing of the home to others. Generally speaking, property law allows owners to lease their homes to other people. I think the concern here seems to be that it's for short durations of time. But when you look at the R100 zone, it simply says that it needs to be a single-family detached dwelling, and it defines the parameters and the scope of that dwelling, and then says all reasonable uses are allowed within that zone. And so, as just as a homeowner buying a home that we did intend to rent out. We let our family stay there when they come in from out of town. You know, we use it when we want to come up this way, but we do short-term rental it. Looking at the code, there was nothing on the face of the code in R100 that would prohibit us from doing that. And there's nothing in the law, my understanding, I'm actually a lawyer, but I'm not a property lawyer at all, so this is like relatively new to me, but I did think that we tried to do our due diligence before we bought the home. There's nothing in the law that says you can't be compensated as a homeowner when you lease the home out. So the fact that we're receiving compensation shouldn't be a deciding factor or influence whether we're violating the zone. In fact, it's an expected standard use of the property. The notice of violation itself doesn't cite any standard that has been violated. It tells me what the zone is, and then it tells me there's a definition of a tourist home. But I looked at that violation very carefully, the notice of violation, and I have to ask, what is the violation? How am I offending the R100 zone that we're allowed to be in? And I couldn't answer the question because I don't see anything in the two provisions cited in the notice that tell me that we cannot do what we're doing. The tourist home is defined in the definition section. I looked at all the definitions. There's more than 200 definitions in that section. It's defined, but there's no other reference. There's nothing connecting R100 and the permitted use that we have in R100 with the definition sitting in the definition section of the code by itself. So I'm really not sure how the existence of that definition would function as a restriction on our ability to lease the home out. By interpreting tourist home as restricting the standard use of R100 single-family detached dwellings, the city, I think, alters a very standard use of residential homes without clear and unambiguous notice to ordinary citizens. On the legal bit of it, laws restricting property rights should be unambiguous and clear. We all value our property rights very much. And zoning ordinances, I mean, in my letter, I gave you the case citations if you want to see them, but zoning ordinances should not be interpreted to insert words or phrases that don't appear in the code itself. And even the notice of violation had to explain in their own words short-term rentals. They had to use that word in the notice, but that word doesn't appear anywhere in the code. Although codes must be read as a whole, the coexistence of the R100 zone and the definition of tourist homes does not connect the two. So it's our position that to prohibit us from renting our home for different periods of time, and we do rent it for different periods of time, you know, it can be a couple weeks, can be a couple days. Sometimes it's not rented out at all. I mean, if there is going to be a fine imposed, you know, obviously the days that we're not renting it, I don't think a fine should be imposed because at that point we're just owning the home and not doing anything with it on those days. But to prohibit short-term rentals, something more needs to be said. It can't be assumed against us that short-term rentals are prohibited. There's a case that I cited and I talk about in the letter that I think is very important to look at. It really goes over these details. It's a case relating to a restrictive covenant called Santa Monica Beach Property Owners Association versus Accord, and it's a first DCA opinion. But in that case, the Property Owners Association wanted to say that the restrictive covenant disallowed short-term rentals. And the court did a really good analysis saying, number one, that restrictive covenants are interpreted in the same manner that zoning ordinances are interpreted under the law. But that restrictive covenant didn't have any language that prohibited short-term rentals. And to impute such a restriction would cut against the principle that such restraints are not favored and are to be strictly construed in favor of free and unrestricted use of real property. And I have a number of cases I cite in the letter that are to that effect. So on all of that, I really ask that you fairly consider the way that the ordinance and the code is structured and that you remove the notice of violation. I'm happy to answer any questions, as is my husband.
You admitted that you sometimes rent the house for a week or just a couple days at a time?
Correct.
Okay. And you cited some rules of statutory construction, but you didn't cite the rule expressio unis et exclusio alteris, which means the expression of one is to the exclusion of the other. And you said you reviewed the code. Can you show me where in this R100 district it says that you can have a tourist house?
Well, in the R100 district, it says I can have a single-family detached dwelling. And if you look at the definition of tourist home, it also talks about single-family detached dwellings.
That are rented for 6 weeks or less.
That is correct.
And you said that you rented it out for 6 weeks, for less than 6 weeks at a time.
Yes, but my function is that, my position is that by placing it in the definition section alone, doesn't put the property owner on notice. I mean, what may happen here is that the city has essentially created two provisions that perhaps are in conflict with each other, but if you're going to expressly prohibit tourist homes from being in residential districts, that needs to be clear in the zoning for that district.
In the zoning regulations, it says what is allowed, and if it's not provided in what is allowed, then it is not allowed. That is how zoning rules and regulations work. You can't have something in a zoning regulation or in a zoning district that isn't allowed pursuant to the regulation. And the zoning R100 does not have tourist homes as an allowable use in the R100.
Yes, the zoning R100 is for single-family, includes permitted use for single-family detached dwellings, and then it states that single-family residential districts are established to provide for detached dwellings in a variety of districts with a full range of dimensional and density standards compatible with the established development of the area. And then the single-family detached dwelling is defined as a dwelling which is designed for and occupied by not more than one family and surrounded by open spaces or yards, and which is not attached to any other dwelling by any other means. We are allowed to rent out the home for compensation. I believe that is true.
You are.
For 42 days.
Yeah,
Yeah.
for 6 weeks or more. You
6
can rent
weeks
the
or
house
more.
out,
Right.
not for less than that in the R100 district.
I understand your position, and we believe that it is not clear and should be unambiguous.
Is that, are you finished with your case?
Yeah, unless you have any more questions.
Okay.
Thank you
Any
for your
questions?
impartiality.
Any question from the board? Okay, the city like to summarize its case, please.
Do you want to just leave it the way it is?
We have nothing more to add.
Okay.
Okay. And, if you, let's see.
You can close the
Yeah,
public hearing.
public
and
portion
bring
is
it to the
closed.
board
Right.
for deliberation.
Okay,
The only-
and
the only question
Can I
I
get a
have-
motion, or? Can I get a mo-
R100, Ms. Stoner, it is at least 42 days, correct, that they have to rent?
It is a
Greater than
minimum,
42 days,
it is a minimum of 6 weeks.
6 weeks?
Yes.
Okay.
okay. Can I get a motion?
Case number.
Someone's gonna make a motion.
Yeah. I move in case number 23-800006062 to find the respondent in violation of City of Tarpon Springs Code and Ordinances, Section, let's see. Section 241.00, 225.02, for the property located at, let's see, 1410 Poinsettia Avenue, and assess a fine of $75 per day, beginning on the date of May 9th today, correct?
May 25th.
But assessing on the date beginning on May 25th,
Correct. They have
Okay.
until then to revise
Okay.
their listing accordingly.
until compliance is achieved, and to order the respondent to contact Code Enforcement Division to arrange for a reinspection of the property. In this case, it would be that you would have to make sure it wasn't online, correct? That it was not listed anywhere?
It could be listed online, it just has to have a minimum of a
Okay.
6-week night stay.
To verify compliance with the board's order.
Second.
A second? Any discussion from the board? Bobby, can I roll call, please?
Yes, sir. Mr. Ogle?
Yes.
Mrs. Archer?
Yes.
Mrs. Telliar?
Yes.
Sorry. And Mr. Perfidio?
Aye.
That completes your roll call.
And one abstaining.
Abstain, yes, sir. Yes, ma'am.
Yes.
Okay, and can the city summarize its case, or summarize?
Yes, you have until March 25th to revise your listings and provide that the house is rented for a minimum of 6 weeks.
The next item on the agenda is item 23-8000065, and it's amirhouses.com LLC, 709 West Bayshore Drive, Tarpon Springs, Florida, 34689. Is there anyone here for that case? Okay. Please take a stand, state your name and your relation to the property.
Good afternoon, everyone. My name is Amir. I'm the manager for amirhouses.com.
And you were sworn at the beginning, correct?
Correct.
All right, thank you, sir.
Okay, and do you have any objection to the evidence being provided by the
Well,
city?
hold on, you have to give her the opportunity to present the evidence first.
Okay, well, okay. It should be on the
It's
binder.
nothing
next to it
here,
as well.
and I have not been provided with anything so far.
Okay, and have the city, please.
This is not a homesteaded property. On March 29th, 2023, I inspected the property located at 709 West Bayshore Drive due to a citizen complaint. The complaint was regarding the residence being utilized as a short-term vacation rental or tourist home, and that it was remodeled within the last 2 years without permits. This property is located in a single-family R100 district, which does not allow for short-term vacation rentals. Upon further investigation, a listing was found on Booking.com for the residence, which allowed for nightly rentals. With this booking were multiple photographs of the inside of the residence. Another listing for the sale of the residence was also located on Zillow.com and also included photographs of the inside of the residence. The residence was owned by the same property owner for both listings, as the phone numbers, websites, and language were the same. It was evident by the photographs that the inside of the residence had been remodeled with new kitchen cabinets, countertops, bathroom showers, flooring, and windows. However, no permits had been applied for, approved, or issued for any of the work that was completed. The property was posted with a notice of violation with a compliance date of April 14th, 2023, a copy mailed to the property owner via certified mail and posted at Tarpon Springs City Hall. On April 11th, 2023, I received a phone call from the property owner, Mr. Amir. He was extremely upset that he received the violations and disputed each one. He stated that he owns multiple properties in different counties and that all of these allegations are stemming from a neighbor dispute next door, as those property owners do not like him nor his tenants. He also disputed that the residence was being utilized as a short-term vacation rental, as the current tenants currently have a year-long lease for rent. He then stated that the tenants reside out of state much of the year as well and may possibly be renting it out on their own. He was advised that if this was the case, he would still be responsible for what the tenants do on the property he owns. The owner also disputed the property being remodeled and that it hasn't been since he has owned it. He advised the photographs were seen online, or I advised of the photographs that were seen online. He continued to dispute the violations and stated, "I don't have time for games," and he is not going to entertain this case and was contacting his attorney. Shortly after this call was finished, I received a phone call from the current tenant, Stephen Hupfer. Mr. Hupfer stated that he just had an angry call from the property owner regarding the violations, that he does reside out of state much of the year and has been renting the residence online to people. He was advised this was not allowable in the current zoning and that it was also not eligible for a conditional use permit. He was very upset by this and stated he would speak with the property owner again. Several hours later, I received an email from the property owner. He provided a copy of the year lease for the current tenants and apologized for being frustrating over the telephone and said, "I'm just very busy and I do not have time or patience for nonsense." He went on to state that the complaint was due to the neighbors next door that had been ongoing for over years. He stated, "You mentioned some pictures you saw online and made an assumption that the place had been remodeled. To my knowledge, no remodeling work took place under my ownership, and code enforcement do not operate or open cases based on pictures or assumptions. I remember a few years ago, a tenant deducted 1 month rent to replace kitchen doors or paint them and do some flooring work, but at that time he said he asked the county and they said that type of work doesn't require a permit. This happened a few years ago, and honestly, I'm not 100% sure. He then wanted confirmation that the case would be closed. I responded to the property owner and again advised of the violations, the reason for the violations, and what needed to be done in order to come into compliance. Shortly after, I received an email from the tenant again, Mr. Hupfer. He advised that the rental booking had been removed from online. Right after, I received another email from the property owner. He advised that the tenant had removed the listing and stating, "I found your approach unreasonable and it appears that you are overreaching your authority, making the scenario bigger than it actually is. There is no legitimate evidence to continue with the violation. The pictures you are referring to were posted online with no dates. There is no way of telling when they were taken. Regarding the alleged remodel, you are insisting on continuing with this case without any solid facts, which makes me feel like you are targeting and nitpicking on me and my clients." A reinspection was completed on April 14th, 2023, and found that no further efforts had been taken to bring the property into compliance. Further inspections were also completed on April 20th and 26th, 2023, found the same. Due to noncompliance, the property is referred to Code Enforcement Board. Over May 2nd and May 3rd, 2023, the property owner emailed several times with the city attorney, Mr. Salzman. The property owner continued to dispute the violations. He also stated that I have owned this property since 2014, and I must inform you that I'm not interested in attending any hearings. Compliance can only be achieved by not utilizing the residence as a tourist home, and with the use of a licensed contractor and proper permits. Permits are to be applied for, approved, and issued for all work that has been completed inside the residence. A hearing notice was posted on the property on April 26, 2023, a copy mailed to the property owner via certified mail and posted at Tarpon Springs City Hall. The division recommends giving the respondent until June 2nd, 2023 to achieve compliance. If compliance is not achieved, the suggested daily fine amount adopted by the board would impose a fine of $150 per day, beginning on June 3rd, 2023, until the property is brought into compliance. On Exhibit 2, this is going to be the original Booking.com posting for the short-term rental or the tourist home. The next page is going to be a listing that is current that just went up about a week ago by the respondent, listing the house for rent for $2,400 a month, along with a photograph of the inside of the house. If you notice, the photograph is the same as the one for the Booking.com. The next two pages are going to be the Zillow ad that had the house for lease to rent to own that was posted by the respondent. It also was attached 11 photos of the inside of the residence. The next group of photographs are going to be photographs that were attached to the Booking.com listing for the short-term rental, and you can see that the inside of the residence has been completely remodeled. The next one is going to be another search for the residence that comes up on the respondent's webpage, showing that the house is again for rent, and it has the same photographs in it. All the photographs are also attached with that. Exhibit 3 is going to be the notice of violation, the certified mail receipt, the signed green card, signature card, and the affidavit of posting, along with the notice of hearing for this hearing, the certified mail receipt, and the affidavit of posting. Exhibit 4 is going to be the property appraiser, tax collector, as well as Sunbiz. And Exhibit 5 is going to be all of the emails that had gone back and forth between myself and the respondent, his tenant, and other members of the city. As of today, the listing has been removed. However, no permits have been applied for at this time.
Board have any questions of the staff?
I do have one question. The last one, you had the DBPR file from the state. Is there one available for this one as well, or was there not one when you researched it for this property?
No, I did not research that. I only did the corporation Sunbiz for the property owner.
Could I ask a question? In your research on this property, were there any building permits issued within, say, since 2014?
There's been no permits issued for this residence since 2005.
Thank you.
Okay, and now you have any issues with the evidence? That's the first question. You see that.
I have a lot of issues with the no decency. I have no intention to be in the front of the board, in spite of I'm honored to be here. Today it's my daughter, Nadia, her name, graduation party, and I have to be here. When I did everything I can to communicate with the code enforcement to achieve what she asked for, in the beginning she asked me to provide a lease for Mr. Steve, which I asked him, and thank you for him being here, the person that leased the place from me. I did provide the lease, and I can immediately feel that it's way more to it than I thought. My point is, yes,
Okay, you can
Yes.
present your case. I just want to make sure we can enter this into evidence. So-
Yes, please.
Okay. Bobby? Okay. Now you may present your case.
It just, I have to own many homes in Central Florida. I don't have much in Tarpon Spring. It's the only one. And this is a result of foreclosure. I used to buy bull mortgages. It's got foreclosed on in 2014 approximately, and we took over. The reason I am here today, I try everything I can to even get an address where is the hearing, as I have not have decent communication with the code enforcement. I reached to Mr. Andrew, and we spoke yesterday. I was hoping to receive an email from him. I contacted his office twice this morning, tried to see if there's something being taken care of, as I show good faith by terminating Mr. Steve, and of course against his will. But I told him I don't have, yes.
Understood, but, okay, we have documents here that show you've been contacted and given ample time to respond. And
I removed the
your
listing,
problem.
basically. I terminate him. He removed the listing. It's not, okay, what the question? I'm sorry, I'm just.
I just don't know what your case is.
My case is, Mr. Steven, he used it as a home with his family. I verified this from talking to the neighbor. He say her grandkids play with his kids. Beside the point, I terminate him, even if he's a good client, and his lease is up actually next month.
Okay.
He's not longer in position, like she indicate, the property online for sale or lease. The other issue she raising after this become to the light because of the listing online or their short rental is, I'm not here to defend that. This for Airbnb and some other people. I, out of courtesy to my time and everybody else's time, and this is more important of all of our use, I terminate the tenant. This, something is not longer there. I have a problem with her try to get pictures off of line with no way of telling where those pictures being taken, or neither nor if work being done and when. And I think she overreach, and this out of retaliation.
Okay. Understood. Okay, that's your opinion. Thank you. Okay. So does the board have any questions of the defendant?
The pictures that were obtained that are different, where did you get those pictures from? The ones that looked like the place had not been renovated?
They
The
were-
early ones?
They were online. Just if you do an address search for
Oh.
that address, they popped right off. It has since been removed, but it was readily available for anybody online.
Okay, so those pictures were ones before what's listed here in Booking.com?
Yes, ma'am. And if you do look at the pictures, the old pictures,
Yes.
it does have his phone number for his business listed on it.
Oh, interesting, yeah.
I want to make one more clear things, if I might.
You're
Yes.
finished, sir.
Yes,
Okay,
no
this
problem.
is,
I do have a question. Do you have any photos or evidence of the condition of the interior of your house when you purchased it? You said you purchased it out of foreclosure?
It was a foreclosure and being rented for maybe 15 rentals since then.
Yeah, I'm not talking about the rental.
Yes.
The condition of the interior, you're saying you have done no upgrades.
Sir, no, sir.
So do you have photos showing that this interior is still the same as it was when you purchased it?
This property owned by Amir Houses that own my younger brother Tarek, which you can see that on Sunbeds. I own Livable Solution and Ideal Houses. And no, sir, I have no pictures for this property from before, and neither nor the code enforcement provide any pictures showing where they've been taken, other than, oh, I see it somewhere online. I don't think it's efficient. And for my phone number, anybody can post anything online, and anything can show like somebody number or somebody picture. It's no real evidence I am seeing here that there is work, and
Okay.
neither nor.
okay.
Yes.
Thank you, sir. Okay. Any other questions from the board?
I do have a quick question for Ms. Stoner. I'm looking at the property appraiser's records, and it shows that there's no recent sales on record. So that would cover quite a number of years, and that there's no deed for this house recorded.
No, ma'am.
Okay.
I do want to add, though, the respondent did speak with Sergeant Miller, and he requested we can come out and take photographs of the inside of the residence to show what you're saying, and he refused that opportunity.
Okay.
So would the city like to summarize its case? I'm sorry, any questions? Sorry.
So I just want to be clear, sir. You're saying the inside of that house has not been renovated at all, but you're not willing to submit to any kind of reinspection to verify that?
The reason I am a little bit sensitive to this matter, I am from Jerusalem. And when I came here, I came in 2002 as a young. One thing I don't understand, and I'm saying this on record, what the sergeant was telling me yesterday, he tried to create a ground, which I only see this in Middle East, to enter my home without my permission and no reason for it.
No,
My issue with this,
I object to that statement because the sergeant was requesting, the sergeant does not use Gestapo tactics. And I take offense that you would talk about our police department.
all due respect, you guys bring the action. You need to bring the evidence. You not try to tell me to get in. Basically, I am guilty till I prove otherwise. And this is not acceptable in my opinion. However, this is something I have no control over.
Okay, thank you very much. Okay. Any more questions from the board? Will the city summarize its case, please?
We have nothing further, sir.
Okay. Okay. With that, I'd like to entertain a motion, please.
I move in case number 23-8000065 to find the respondent AmirHouse.com LLC in violation of City of Tarpon Springs Code of Ordinance, Section 241.00A, in parentheses 213, 25.02, and 6.1, or 6-1, and the Florida Building Code Section 105.1 for the property located at 709 West Bayshore Drive, Tarpon Springs, and to assess a fine of $150 per day beginning June 3rd until compliance is achieved, and to order respondent to contact Code Enforcement Division to arrange for a reinspection of the property to verify compliance with the board's order.
Second.
Okay. Bobby, call the roll, please.
Mr. Ogle?
Yes.
Mr. Rollinson?
Yes.
Ms. Archer?
Yes.
Mrs. Tilliard?
Yes.
Mr. Papidio?
Aye.
Motion passes.
You have until June 3rd to pull the required permits for all the work that was done on the property and to remove any listings that advertise the property for rent for less than 6 weeks.
The listing is being removed, but can you be specific what permit you require?
The permits for the work that were done to the property from the time that the sale was posted to the time that the pictures were posted.
And how we define that? This on record is going to go to court.
You can go to the
Yes.
building department, and the building department will review the photographs. I can tell just from looking at the photographs that there was electrical work that was done that probably wasn't permitted because the appliances are in different locations.
Which picture are you referring to, just so I
The
understand?
pictures that were entered into evidence that are in that binder right in front of you.
And what their date on them, and like when they've been taken, what the source of those pictures? Did the code enforcement took those pictures?
Yes.
The code enforcement take those pictures?
The code enforcement pictures that are now part of the record, sir. Yes.
I just heard.
Okay, sir.
Yes, no worries.
This case is
This
finished.
case is
Thank
done.
you.
Thank
You need
you.
to take it with.
You guys
code
keep the hard
enforcement.
work.
Okay, thank you. Okay, the next case is affidavits of noncompliance, and it's 23-8 000019, the Palms of Tarpon Springs Condo Association Incorporated, 600 Haven Place, Tarpon Springs, Florida, 34689. Is there anyone here?
Hey, y'all.
Yes. Okay, how are you?
You're going to be sick of me eventually.
Yeah, it's okay.
Good afternoon. Robert Todd on behalf of Palms of Tarpon Springs.
Okay, let city present its case, please.
Yes, this is an affidavit of non-compliance. The compliance date was on April 10th for the property to submit permits for demo remodel of the burnout condos. At this time, no permits have been applied for. Exhibit 1 will be the affidavit of non-compliance. Exhibit 2 is going to be the prior board order. Exhibit 3 is going to be the notice of hearing, along with the certified mail receipt and the affidavit of posting. Exhibit 4 is an email that I sent over to the building department just to verify that the permits had not been submitted. The worker, I guess, did submit an attempt at an approval process. However, no attachments were sent, the wrong information was sent, and the permitting tech did speak to the contractor, let them know what else was required, and since that time, there's been no further contact back. They actually did start doing some demo on the units, however, without permits, so our building inspector had to go over and post a stop work order.
Okay. Any questions of city staff on board?
I have a question. These are individual units, though. They're hooked together, but they're individual, and the parties involved were individually seeking insurance and so forth to deal with each one of their units, were they not?
Yes, ma'am.
So when you're saying that there's no permits for none of the work on any of the ones that were burned out?
No, ma'am.
Because one of the people who came before us last time said that she had a check and was ready to go on her property going forward.
The problem is the association owns the outside of the building, so the tenants that have insurance can't do anything for remodeling until the outside of the building has been remedied, then their insurance steps in. But until the outside is taken care of, they can't do anything.
Okay. Thank you.
Any other questions from the staff, from the board, sorry?
I just want to clarify, because you said something was submitted, and then the building department responded and said that they had to get certain things in place, or they had to do something differently, is what you said?
I can defer to the building official.
Okay.
Mr. Mead's here.
Perfect.
All right, please state your name, your position, and indicate if you've been sworn.
Keith Mead, Deputy Building Official, City of Tarpon Springs. I have been sworn. Yes, they did attempt to apply for a permit, but it was very insufficient. All they did was upload a document with an estimate for the construction. That was it. There was no application, there were no follow-up documents. We emailed them immediately and said, this is insufficient, if you can give us more information, here's what we need, and we never heard back from them.
Do you give them a specific amount of time to respond?
Well, this has been since April 19th.
Okay.
So it's been almost a month since we responded to their application, and we haven't heard anything from them.
Could you tell me who you contact there? Who are you contacting to get this
The
done?
person who uploaded the permit application, it wasn't even a permit application, like I said, it was just an estimate for the job. That was all we received. So Michelle Donino, the permit tech, emailed them immediately.
Who is them, though? Who are you emailing to? Is it a particular person at that?
This one is, the email address is bobby@trusturs.com.
Is URS United Restoration Services?
Very possible, because that's the company that was doing the work out there.
Did you check, is there a general contractor license for?
They do have a general contractor's license with the state, but I could not find anything to show that they were registered with Pinellas County, with PCCLB,
Oh, okay.
correct.
Okay. So, excuse me, go ahead, sorry.
Okay. Any other questions from the staff? Okay. And do you have questions, sir?
I do, because I'm in a little bit of a state of confusion here. You work for the city here. Is your relation, and I've been communicating just with the front door that's over there when you come in on the right. Is that your department, or is that a separate department?
No, that's my department, yes.
That's your department?
Yes.
Okay, great. Because in preparation for this hearing, I went over there and I said, look, we've got an application that went in on April 17th. Obviously, it hasn't been approved yet. We're here almost a month in. What's going on? Me trying to figure out why it hasn't been approved. And the response that I got is that there's a separation between the departments, and that they had to, as of today, send a request to the other department for the documentation, that they hadn't received it yet, that it hadn't been sent. I just spoke with that lady not a half hour ago.
I'm not aware of the conversation you had with that person.
Of course you're
But I don't know, they sent us, they attempted to apply for a permit. It was
Okay.
insufficient. We notified them it was insufficient, and email correspondence, there has been none since then.
Okay, so there's been an application, at least we can agree to that, and it hasn't been approved because in your expert opinion, it's insufficient. I have no reason to discount that. I'm just confused because my most recent interaction with your department was that they were, basically the ball was in their court to submit a email request for additional documentation that hadn't been done yet because there was protocol between the zoning and the building departments wherein what they communicate to one another, they have to make separate requests for documentation. This is just what I'm being told in preparation for this hearing and in advance of the same, because I, like you and the rest of this board, want nothing more than this to be done. And so here I am showing up thinking, you guys are dragging your feet, and you're telling us we're dragging our feet, and I have no reason to discount you on that fact, but that's where we are. So I can tell you, the board, and thank you, I have no further questions on that. Although I think perhaps I can request documentation relative to what's been submitted after the fact, because I think, at least according to this binder, it ends with your last guy. I don't know if you put all the documentation for our hearing in here or not, but it ends at 3.
That is it. The only other thing that was part of this was the email attachment from the building department, and it was the United
Because it's not here.
It's in the stack with the clerk. It was about 100 pages, and I wasn't going to put that in everybody's binder. It was just the assessment
Okay.
that Mr. Mead was speaking about.
Okay, well, if we can't review it, I don't know how we can cross on it or question it, but suffice to say that the documentation hasn't been provided for our review for questions. I can say this, that and I have no further questions for the city about what's been submitted at this time either. Who are you? Who are you?
I'm the treasurer.
Oh, I'm just kidding.
Oh, okay.
Have you been sworn?
No, I was just showing you
Yes, this is what we have. This is the application. This is the structure detail. This is the application that was submitted on April 17th. This is the permit. Was there more information, sir?
We just have, if you want additional testimony about when we received and
Isn't it supposed to be on the mic?
what was done in the department, what's in the received.
You need to be on the mic.
Yeah,
Yeah,
please,
come up,
please.
please.
I'm just referencing to the attorney what,
Okay.
if he wants more.
Absolutely, please, because we haven't received any of the documentation in a written form. I'd love to at least have it on the record if it's available.
And also too, for the board, for their education, can you kind of describe for them what's required for this permit? Like what is required to be submitted for something like
Well,
this?
for the permit, for the work they were doing that we shut them down, all we're requesting for is a demolition permit. And we told them that we can have one permit, just list all the addresses, because technically it's one structure with different addresses. So for the demo work, it would be one permit listing all the addresses. Once they finish the demo, then they would go into the rebuild or the build-outs, which would require a permit for each address. Okay? And in the permit application, there's actually an application, and you put down there the company, scope of work, everything like that, and you also submit the contractors you're going to be using, all their licensing information, and so on and so forth. And at a minimum, that's what we...
And is that permit available, that permit application for the demo work available online?
Yes, it is, yes.
And it is publicly available as well. It's applied as of April 17th, and I believe that's what they were referring to when they were saying that there was missing components, that there had been an application, but that there had been correspondence, which we don't have here, but just trusting you at your word.
If I may, I'm sorry to interrupt. I can have Michelle DeNino, the permit tech. She's in the office right now. She's going to come in here, and because she, oh, I'm sorry, she's here. If she can just be sworn in, and she can vouch for when and what was received, because she gets it first and then disperses it, so she would have better knowledge of that information.
Okay.
Michelle?
Come to the mic.
Do you? Yes, please. Right here. Hang on a minute. Right here. Do you swear the testimony you're about to give us whole truth and nothing but the truth?
Yes.
Thank you, Michelle.
Question. Where are we? Where are we?
Well, you were going to
I had
provide us
a
background.
submittal, an online submittal.
Okay, great.
For 17, I think it was. All they uploaded was, it looks like an estimate for all the units to be repaired. They submitted under demo, which is not the right category. So I sent an email and told them that they could do a demo for the building under what they submitted, but I need more information. I sent him the application. I heard nothing back.
So you're saying that you advised them that they were able to proceed with demo on what they provided? Okay.
They could use the application. The paperwork that was submitted was not sufficient. It's not an application.
What is it if it's not?
It's entering stuff into a computer and uploading an estimate.
Okay, so what we have here that's referenced as an application status pending verification from April 17th is classified by
As an application
Tarpon
status.
Springs. Okay, so an application for a permit that requires further documentation is a fair assessment?
Yes, it's an application without a physical application.
Right, because it's online.
No, still, paper's still required,
Okay.
which is what they didn't submit.
Oh, okay, so what are you waiting on?
The paper application and an explanation of what they want to do. They submitted something with a full estimate for each unit, which has
Okay.
nothing to do with demolition.
Okay, that would be subject.
I needed a scope of work.
Got it.
And I needed an application.
Okay, and so there's two different permits, of course, which is what you've already indicated. The first one being demo and the second one being the individual residence.
No one's even approached me or asked any questions about the.
Well, hold on, I'm getting there.
the construction.
So the fact of the matter is, though, is that when we're dealing with the demo permit, which is the first permit to be submitted, that's what's already been applied for, and that's what's before you. And it would be premature to be seeking an application
Sure.
for the individual units.
Yes.
So you're not denying on the basis
Oh,
of
no,
the
no.
individual unit application?
Nope.
So we have an application that's been submitted to Tarpon Springs.
Okay.
It's insufficient. and it needs
Correct.
to be approved.
Correct.
Once you receive the proper documentation. Is that a lengthy process?
No.
Okay. So at this time, you're waiting on what?
An application and a scope of work that matches what they're actually going to do. What they've given me is a scope of work that says everything about the units. Nothing about, I want to demolish this, this, and this, and proceed.
Interesting. Do you have a copy of what was submitted?
The 88-page document, I didn't print it.
Does the board have a copy of what was submitted?
It was submitted with our original documents to the clerk.
Okay.
And it was so large, I didn't want to make copies for everybody, but you're more than welcome to look at it.
Okay. Well, I don't think we need to beat a dead horse on this. I do think that, and
I want to
yes,
add
sir.
one more bit of evidence. Can you show the date that this property was red tagged?
Yeah, we got notification on May 4th, which was 1 week ago, that they were doing the demolition work, and we checked in the system. There were no permits issued, so myself and another inspector went out there and placed a stop work order on the project. And we actually spoke to the owner of the company and advised him of the same.
So you have made contact with the contractor
Yeah, Mr. Paul Strode,
via telephone or email?
via telephone when we were on site.
What was the outcome of that?
We advised him that he doesn't have a permit
Okay.
and that he needs to cease work until he gets a permit.
Okay.
And he advised us that somebody in our office told him he could proceed without a permit, which is completely untrue. We would never, ever tell somebody that. So
I
that was the
believe
extent
you.
of the conversation.
I believe you, and I certainly can't speak for Mr. Strode. He's not my client, nor do I represent him. I'm being advised by the treasurer that, in her humble opinion, and certainly she's not a member of the Tarpon Springs Building Department, that there is an application for demolition, perhaps not to the sufficiency of the building department's criteria, but that it is in the 88 pages that we don't have here before us.
We do have the 88 pages. It's held by the secretary down there. So the clerk.
Okay, let me take a look at it.
Do you want to take a brief 5-minute recess?
Okay.
If
Yep,
we
we'll
can.
recess for 5-minute recess. We're reconvening the Code Enforcement Board. Okay.
Okay, back at it. So I did go ahead and get an opportunity to look at what was submitted through the portal, and I think I see in agreement with building that there was a large amount of documentation that was submitted. There is apportionment for demolition in there throughout the document as it relates to each and individual category, but of course it's not submitted with its own application. So the documentation necessary to perform the permitting on both fronts, both the demolition permit and the ladder building permit, are here. They're just not in the appropriate form for approval. So, and as much as I would love to fall on a sword that isn't mine, we have a contractor that I need to hit with a bailiwick. That being said, we have attempted compliance in having our contractor submit, although after the April 10th date, by April 17th, that documentation being already prepared and more or less just needing to be populated into the permit application in order for permitting to provide the appropriate permits. There is not an attempt to drag our feet or otherwise slow this process down. It's literally all right here. There just needs to be, as my esteemed colleague is about to attest to, a secretary to populate it. And I would ask for her to be sworn in and to give her testimony, as she's been working very closely with the contractor on this project, and she's an owner in the building.
Pardon? She's, say again?
I'm an owner.
She's
I'm an owner.
An affected owner.
Okay. But
Do you swear the testimony you're about to give is whole truth and nothing but the
speak in a
truth?
microphone, please.
Yes, I do.
Thank you.
Hi, my name is Jennifer McCormick. I'm owner of Unit 718, one of the units that was burned down. I do not live at the property, but I'm trying to attempt to help this process. The president, Rachel Spengler, told me the name of the contractor. I have been in contact with the city to try to figure out what the issue is exactly. I've spoken to Bobby and Paul today, and Bobby is in charge of applying for the permits. He's the contractors, okay? He's in charge of applying for the permits. They're both Texas boys. I'm from Texas, okay? So Bobby, yes, he did apply. He basically made a profile to apply for a permit. The city is telling me that, and I completely understand, he hasn't done the application, number one, which you have to do the application. He started the application. You have to fill out this form.
Understood.
Yeah, you have to fill it out, which I was telling him. And he did give that 88 pages, but what all you wanted right now is an application for demolition, and you wanted the a scope of work, correct?
Correct.
Yes, I am going to be helping Bobby with that because it seems like he needs a secretary, because it's in my best interest to make sure that this gets done quickly, because it's costing me a lot of money. So I will make sure that Bobby, that information is going to be uploaded to the system. I, as a homeowner, because I'm not the contractor, cannot pay for the permits, but I will call Paul, because I have him on speed dial, and have him pay over the phone. I am asking for leniency for this. We have had a horrible time with our association and everything.
Yep, we
Okay, so the
understood.
permits have already been paid for, but we will do the correct paperwork, and I'll make sure it gets done.
Okay.
Okay.
Okay, thank you.
So I will let the board know that you do have the ability to consider as one of your factors the efforts of the respondents to come into compliance. That is one of the three things that you can consider with respect to this situation.
Would the city like to summarize?
Just remind the board that this has been a process for over a year.
Yeah.
We gave them an extended amount of time just to apply for a permit, and we're still not in compliance at this time.
I just started to help, and I'll get things done. Okay.
Well, and to address it from the association's final standpoint, from the association's perspective and the perspective of the board of directors, the information that it's receiving is that the permits were applied for, paid for, and submitted by our contractor no later than April 17th. They're not showing an indication of intent to avoid compliance with the board. We're dealing with a situation where all of documentation that was submitted in that large packet is what will eventually be the permit. It's just not appropriately earmarked in the way that will allow the permit application process to be approved for. I can tell you, coming into this hearing, I was under the impression that the $1,073,000 permit application had been applied for on April 17th by virtue of the communications from the contractor. Obviously, the extent of it necessary to obtain approval hasn't been received, but that wasn't the original order of this board. The original order of the board was to submit for the application for approval because there is no basis by which we can time the approval from the department. Any fine or penalty levied at this point in time, I understand the board's position in feeling that it has to do something. Those fines and penalties are going to be subject to dissolving amongst the members of the association as a common element expense that they're going to have to pay from their assessments. There is nothing further that a fine or punitive action at this time will do to expedite the process. We have submitted everything that we believe necessary at the time, and at this point in time, all that's necessary is to properly separate the documents into a demo permit and a building permit. And it's all before you.
Okay, thank you. Okay, that closes the public portion of the case.
Can we make one more comment?
Yep.
I'd like to make one more comment. This came before us, I believe, a month ago, and there was a distinct feeling from what was presented that there was no sense of urgency, but yet there were people. There was a woman that was actually had been living in her car. So basically, before you say what you're going to do, what we'd rather see is that you really understand that some urgency has to be applied to this because these people have really, suffered a lot.
Understood.
Okay.
I will make sure that the application is in today.
Okay, the public
Today.
portion
Who
is
checks
closed.
up on it after, though? What's the next step after that? Everybody says they're going to do it, but what's the next step? Who follows up? Because that seems to be part of the problem also, that there's been no follow-up. You send it and you wait, for the sun to rise or whatever, but some follow-up has to occur.
If all that's needed is the scope of work broken down to the demolition, I can get that in. And the application, I can get that in. And payment. I'll even front the money and make them pay me back.
Okay, great.
You know.
Okay. That concludes the public portion of the case. Can I get a motion, please?
There was someone else that wanted to speak. No.
Are you?
Closed. You didn't give her a chance.
Oh, okay. Sorry.
All right,
Yep.
you have to be sworn.
Have you been sworn in? Okay.
Okay.
Can you go to the microphone, please? Thank you.
All right. Please excuse my speech, but I had surgery on my top lip
Need
this
to
last
state
Friday.
your name and your address for the record, please.
Okay, my name is Jakesha Williams, and my address is 720 Haven Place. I'm just here to say I've been homeless since March 14th, 2022. The first action I took was going to a shelter, but that didn't work for me, being that people would steal my belongings at night when I went to work. Complaining to staff didn't help. They said that it was out of their hands. So I left that shelter and erased shelters as an option to stay. The insurance money that was given out for residency was short-lived in hotels, so I started sleeping in my car. At times I couldn't afford a room. I still pay my mortgage. Fees, the HOA fees are still being billed to me, in which both has went up hundreds of dollars this past year. I've maintained my job for 5 years throughout this process. So I'm paying taxes, yet still, if I sit in a park too long, police harass me and follow me. I understand that my situation makes them investigate me the way that they do, and it's very annoying and traumatic being treated like I put myself in this situation. And the circumstances I've been put in puts me at risk for numerous mishaps, whether with police or other homeless people that's living on the streets. I moved to Florida in 2018 from Georgia. by myself, so I have no family here or friends to help me with anything. It's just me trying to take care of myself in the situation I was forced into. The sooner these permits are granted, there's one less homeless person on the streets. At times, I park on the property to stay overnight because it's safer for me there. And I like to remind myself that I do have assets and that I'm not a bum. I'm just temporarily homeless. Thank you.
Thank you. Is there anyone else who needs, from the public, wants to comment on this case? Okay. If not, that'll close the public portion. Now, will the board make a motion, please?
So you all have received the evidence and you have the discretion to evaluate and weight that as you see fit in accordance with the criteria, the gravity of the violation, attempts at compliance, and whether or not, it's a repeat offense. And the original date set was the April 10th with $250 per day. If you were going to treat the application, because a lot of times when you get like the building permit applications, it's not unusual for them to be incomplete and for the building department to kick them back and need additional information to process permits. That's something that happens all the time. Usually you get 30 days or so to respond, and under Chapter 553, when you look at buildings, the city actually has an obligation to respond within 30 days when they receive these types of applications. So from the April 10th compliance date to the 17th, when the permit, when the information was submitted to the city as an application, at the $250 a day, that would be approximately $1,750 of a fine and penalty. So you have that, if you want to consider that, or whatever the board feels is appropriate.
Question.
Excuse me. I am a licensed community association manager. I deal with a lot of condominiums. The unfortunate thing here is that the burden of this compliance is really lying on the board, but it affects all the residents and the owners. Unfortunately, they can't put blame back onto the contractor because ultimately they're responsible for the contractor. However, when it comes down to fines and paying these sometimes very large penalties, it falls on the homeowners, even though it's the board. I would like to recommend that we, at this point, forgo the fee or the penalty, but we need to ensure that this board reacts, because it has been a very long time.
Okay,
I
can you
remember in the very
clarify the board, are you talking the homeowners association?
the board of
Okay.
directors for the condominium
Okay.
association. They're the ones that are responsible. The owner is going to pay the burden. They're going to pay the price. So I would like to set the fee aside, but I think we need to put a very strong message to this board that they have got to get this done. I remember in the very first meeting that they had, we were told then, and I specifically asked if the engineering was ready to submit a permit. I even asked about the not the depreciation, but the deductible. That was all satisfied, and they were ready to submit that day. That was 2 months ago. So that's, I really would like to see for the homeowners, not to pay, not to be burdened with that fee, but their board of directors need to have something to entice them to react.
So ultimately, one of the things that you have to decide is whether or not that they complied with what was submitted on April 17th. If the acts that they took and the steps that they took on April 17th to submit the permit, whether or not that constitutes compliance with your previous order. That is essentially what you're finding with whether or not you're going to impose this fine, and your motion has to so state whether you are finding them in compliance or you are finding them not in compliance. Now, if they do not follow up with the order, if they do not follow up with what was requested by the building department, then ultimately there is another case, it would be a second case, and then at that point it would constitute a repeat violation at the higher fine amounts. So that's something that you need to keep in mind, is that if they end up not doing what they're supposed to be doing in terms of submitting the appropriate documentation to the building department, then it's a second case as a repeat violation that gets opened up.
So would anybody like to make a motion within those parameters, i.e. with mentioning the fine, and also if it isn't met, that it's a repeat violation with a higher fine to follow through, and the suspense date would be?
If you find them not in compliance, then the fine runs from April 10th until the permit is issued.
I will try to make this motion if you can.
Thank you.
I move that, is there a, yes, under case number 23-8000019, I move that the intent of applying for the permit was in fact there. And that they made every effort in the beginning to apply for the permit, and then it's been complicated since. So I would make that motion that they are in compliance with the intent of applying for a permit, and waive any fees that may have been incurred.
So, Madam Secretary, the motion is to find compliance and waive any fees or fines.
Yes, ma'am.
Is there a second?
And if this comes up again, then it would be repeat violation?
Correct.
Okay.
A second. Thank you.
Roll call vote.
Yes. Mr. Ogle?
Yes.
Mr. Rollison?
No.
Mrs. Archer? Yes. Mrs. Cheliar?
Yes.
Mr. Favidio?
No.
Carried 3-2. Passes.
All right, you have been found in compliance, and the board has waived any fines or fees to be assessed against you. If you do not follow through with the permitting and permit application, then you will be treated as a repeat violator under the Code of Ordinances and under Chapter 162.
Get it done.
Okay, thank you for your time. There are no affidavits of compliance. The next thing on the agenda is consent, and it's item number 23-8000036, Thomas Filaratu, parcel number 12-27-15-21078-000-0030, Tarpon Springs, Florida, 34689. And I don't believe there's anybody here for that.
We're
city,
just
please?
asking for the board to accept the affidavit of compliance. The date for compliance was supposed to be April 28th. He came into compliance on April 25th. Exhibit 1 is going to be the affidavit of compliance, and the second is going to be your board order.
Can we do this with a voice vote? Or? Okay, motion to accept with a voice vote.
I move to accept.
Okay. All in favor?
Aye.
Aye.
Was there a second?
Was there a second?
Oh,
Okay.
second.
I'll second.
Saw a head shake. Okay.
Thank you.
Okay. And we all said aye. Great. Okay. No request for reduction. Approval of the minutes, please.
I'm sorry.
Just accept the minutes? Is that what we're
Pardon?
doing? We're accepting the minutes?
Yeah. Approval for minutes motion, or any concerns?
There were two sets.
Yeah, there's two sets.
I think you have to do them individually.
Okay, I guess we have, yeah. Okay,
Um,
for-
If there are no corrections, you can do them both together, but if anybody has any amendments or corrections to the minutes, then go ahead and separate them.
Right. Any questions, corrections,
We're fine.
additions? Nope,
No
okay.
corrections.
A motion to accept the minutes?
Second?
No,
You're making a motion?
You make the motion.
Oh, I'll make a motion. Okay, a motion to accept the minutes?
Second.
Okay, voice vote, all in favor?
Aye.
Okay, great. See, approved minutes, no public comments. Any staff or board comments?
I'd just like to make one comment, and that it's extremely troubling.
Talk into the
Speaking of
mic.
Mike,
Okay. It's extremely troubling when we have a case like that, when we know when we drop a fine on these people, that it would be paid by them, by those people that are already, that one gal is struggling. There's another gal in there that is having her, in her second rental. It's too bad we don't have some other recourse that we can, because they're just gonna turn around and, you know, but they don't, and they professed a sense of urgency the last time, and there
Well,
was no.
that was my,
Yes.
my point was
I
that
was
when
almost
we,
on the, yeah.
when we put the original order out, some of those residents were here with tears in their eyes saying, fine them. It's the only way to get them to
But
move.
then they said, if you find them, they're gonna bill us.
Remember, though, they are eligible for a reduction as they're not a repeat violator. So if any fines were to accrue from this case, they could have always come back for a reduction.
So the board members themselves would have to come back for it, because that's who you're actually fining, and then they turn around and they'll probably not give back the money to the people that they've already gotten it from. You know, that's the thing. So it's kind of a tough situation.
Well,
I don't feel like we did anything today that really gave them a sense of urgency, you know?
I'm sorry, can I
ahead.
speak? I think one of a recourse that they do have, the owners,
Yes.
they can report this board to the DBPR. I don't want to make any, it seems that the board has no urgency,
That's
sense of
right.
urgency. But I think it's personally maybe a board issue, and that may be turning over.
So
We
I
can't do
want to
anything
go
more.
ahead, because this is a case that may very well come back before you.
Yes.
Right.
So
Yeah.
I don't want to encourage additional discussion on this matter. You know, the case is closed, and I certainly do appreciate, you know, your concerns and your comments. I mean, I do understand that this was a hard one. So, but just to the extent that it's going to come back, let's keep those types of comments within the context of the hearings that we have, okay?
One last thing, I did want to introduce Miss Lee. She's our new code enforcement clerk. So you may be getting emails or phone calls from her, so
Where is she?
right here.
Hello.
Hi.
Pleasure meeting
Great.
you all.
Hi.
Thank you.
It is a hard job. I applaud you guys for what you are here for, so thank you.
Okay, well, welcome aboard.
Thank you.
And I'd like to say thank you very much for your time and effort, and especially the board with my, my pilot chairing of this thing. I hope I didn't do too bad, but, oh well, we made through it. Okay, but thank you very much. Next code board enforcement hearing will be held on 8 June at 2 p.m. Thank you, have a good day, and
Hit the gavel.
you police officers, stay safe out there. Thanks.
Thank you.